Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. In every episode, we'll hear from other attorneys, accountants, and other professionals who can impact the success of your litigation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Welcome to another episode of Time is Not on Your Side, where we bring you guests and topics where you're unlikely to hear on just one platform. Today's title for our topic podcast is Personal Injury, an Insider's View. We're going to be talking about tort reform, importance of injury treatment and getting that treatment when you're injured, and what clients should look for when hiring a personal injury attorney. And today's guest, we're happy to have a friend of mine who I know, a colleague, an excellent lawyer, Peter Sartes, personal injury lawyer, home-based here in Clearwater, Florida. Good morning, Peter.
Morning, Rob.
Let me tell you a little bit about our guest today, Peter Sartes. Peter Sartes is a partner at the firm Tragos, Sartes Tragos that started there in 2001. Where he's established a reputation as one of the premier personal injury lawyers and respected personal injury lawyers here, and certainly in Clearwater and Florida and elsewhere, but is well known for his practice, his ethics, his professionalism. Mr. Sartes, or Peter as I like to say, has a degree in finance and an MBA with his Juris Doctorate from the University of Toledo. Importantly, and I think, thank you for this next thing, Peter. You are a honorably discharged member of the United States Army as a combat engineer and armor officer, and you have a rich background and diverse tactical knowledge that you use with your entire training and experiences that I know use in the courtroom. Peter is experienced in both criminal law and civil trial law. He's proficient in analyzing cases to determine effective strategies for outcomes for clients. He's AV rated by Martindale-Hubbell. He is often called upon to teach other lawyers and law students, whether it's through bar associations or universities, on aspects of the law and how to be a better advocate. Mr. Sartes is a advocate for promoting his skill set in the community and gives greatly. And I see that constantly promoting not just his practice, but his care and desire to make the profession better. He is the only son of Greek immigrants and speaks fluent Greek. And this is important, especially here in the Tampa Bay area, but elsewhere. But certainly we have a large Greek community here, and those folks can come to Peter and be rest assured that he understands them and he can communicate with them. Peter is well recognized in terms of awards and distinctions. He's one of the top young attorneys in Florida. He was voted that by the Wall Street Journal. He's one of the top 10 attorneys by the National Academy of Personal Injury Lawyers. He's often voted and achieves the title of super lawyer here in Florida, which is a great distinction. He's rated 10 out of 10 on AVO. He served at the legal community in so many different aspects, including the 6th Judicial Circuit's Grievance Committee, the Federal Practice Committee, the Young Lawyers Division, the Technology Committee. He's the past president of the Clearwater Bar Young Lawyers Division. And I could go on and on, but in the most important, I think, distinction for Peter is that he is an amazing dad and husband to a wonderful, beautiful wife and two really smart, wonderful girls. And he is just an amazing dad. And Peter, I want to thank you for being here today, man. It's a pleasure.
Oh, the pleasure's mine, Rob. Happy to be here.
I hope I didn't miss anything.
Listen, at the end of the day, we all do the best we can for our clients and the community. If you do that, you're a star no matter what the accolades say.
Well, you're a humble guy, and it certainly shows through your work in the community and your practice. So let's jump right into it. Peter, what is tort reform and why does it matter?
Yeah, tort reform basically means that the laws that people have that can give them redress in the courts have changed. Unfortunately, they never changed for the benefit of people. And tort reform happened, it actually started in April of 2023 and is now in full effect in Florida. And what happened is the statute of limitations changed. So now you have less time to bring your case than you did before. Florida has traditionally been a 4-year state. Now it is a 2-year statute of limitations state. Other changes that happen in tort reform. For example, we used to be a comparative fault state. Now we're a contributory negligence state. What that means is, in the old days, let's just say you made a claim and a jury determined that you were 70% at fault for your injury, but the other person was 30% at fault for your injury. You still got to claim and take advantage of 30% of compensation. That doesn't work in Florida anymore. So what happens now is if you are found to be more than 50% liable for your own injuries, you cannot recover at all. Another major thing that happened in tort reform recently is that the concepts of bad faith, which are the tools that you have to make sure that insurance companies, especially your own insurance company, is acting in good faith towards you, have changed. They've been gutted. In the old days, you used to be able to make a claim against your insurance company to say, hey, you didn't treat me fairly. You're ignoring me. You're not giving me proper value for my claim. Those laws have been completely eviscerated. It is, I don't want to say impossible because we haven't litigated all these yet. They haven't gotten into the court systems yet, but the new rules just really place a significant limitation for the consumer to be able to bring any cause of action against their insurance company. All these things, obviously, not for the betterment of the client or the average citizen, but betterment for big business, insurance companies, those types. So because of tort reform, you really need to be vigilant about your claims, and you've got to start quickly.
Let me ask you this, Peter. Let me unpack this a little bit because that's a lot of information, and certainly the viewers are going to have the ability to go back and listen again. But tort reform occurs both at the state and the federal level?
Tort reform actually occurred here in Florida at the state level, but let's just presume that your case gets commuted or transferred out to federal court for purpose of diversity citizenship, or all the reasons where you might be in federal court, but still using state of Florida law. You're now affected in federal court because clearly the state law has changed.
So what I gather from what you just said, two big things for what tort reform means is, one, it makes it more difficult for injured victims to file lawsuits against those that hurt them, right?
Right.
And then two, it limits the amount of compensation victims can recover when they do file a lawsuit. Is that part of it too?
It's not a limitation on the actual compensation they can recover. The limitation is how that compensation can be calculated, and that has had a substantial change. At this point, there are actually going to be, again, those are things that we're going to see here as the law progresses in the court system. The judges are actually going to instruct people what reasonable attorney's fees are, reasonable medical bills are. And what are they using? They're not using the bills of competent, capable surgeons and doctors. They're going to Medicare and Medicaid and using a percentage of whatever those insurance provide their own people as what is reasonable for your medical bills. So there's a lot of work that has to be done from this point forward to really get a client proper compensation.
How much has the impact of the law changing on the statute of limitations, which used to be 4 years, and now you indicate, now I believe you said anything after March of 20,
Yeah, it took effect March of 2023. So as of April of 2023 going forward, that's the new law.
Okay, so it cuts it in half. I mean, that's huge, right?
It does. It's
Okay.
huge, especially when you realize how hard it is to get a case through the process in that short amount of time.
Okay. And of course, then you bring in the contributory negligent or comparative negligent change, which could be a complete bar to recovery. It sounds like all this is wrapped up in the tort reform umbrella or bubble. That's all part
That's
of it.
exactly right. Yep, you're absolutely correct.
Okay. And touching upon that, I know we talked earlier before the show today, but one of the things that I wanted to ask you is how does the effect of alcohol play into if an injured party is either under the influence or is intoxicated? Does that affect an injured party's case?
Absolutely. There is a law in the state of Florida that says that if you are intoxicated and the jury makes an actual determination that your intoxication played a role in your injuries, it is a complete bar to being able to recover. So if you're driving while intoxicated and there's an accident, and frankly, that accident may not be 100% the fault of the other person because of your intoxication, you cannot recover against that person because of your own fault.
Wow. Well, does the law in that instance say that the injured party or the plaintiff has a certain blood alcohol level, or is that a jury question? If let's say that there's just clues of impairment or indicators of impairment, or the blood test or breath test is not above an 0.8, but there was alcohol in the victim's or the injured party's system, does that still come into play later on?
Absolutely. And it is a jury question. And that's why that's such a difficult concept to really grasp. It's because it's a jury's determination whether or not the intoxication led to your comparative fault. Meaning, did the fact that there was alcohol in your system actually contribute to this injury? And if the answer is yes, you are barred from recovery.
Well, that again is another factor that folks need to aware, especially here in Florida, where we live. Three sides of this are water, and quite a few bars on beaches and boats, and people participate in your holidays, and a lot of drinking going on. And sometimes, as you said, the other person may be at fault, but if you are the one that has alcohol in your system or deemed impaired, no matter what they did, you could be completely barred from recovery.
That's right.
Let me go on to the other point. One of the other points we want to talk about today is you had indicated that it's really important for someone that's injured to seek medical care and treatment right away. Why is that, and how do they go about doing that?
Right. Now, the reason it's important now, and let me kind of walk back to the way it used to be. People would, get in a car accident and they would, I'm fine. I don't need an ambulance. I'm not bleeding out of my arm. My legs aren't broken, thank God. And they would just go home. And over the course of the next few days, they determined, man, I'm not feeling right. So they ultimately would make an appointment with their primary care physician, who would pretty much tell them, oh, you were involved in a motor vehicle accident. We don't see motor vehicle accidents. You've got to go somewhere else. And people had time to engage in that process. The way it works now is that time is gone. So when people are involved in a crash, and I understand that most people don't want to be litigious. You don't want to feel like the first thing that happened is you're running to a lawyer because you want to make a claim. But you almost have to do that, because if you're not doing that, you're not protecting yourself. First of all, you're not sure if you're actually injured. You're not getting an evaluation from a physician that can at least tell you, is there something here? Is this a condition that is causally related to a motor vehicle accident? Do you need some muscle relaxer so you don't feel like a truck literally hit you over the course of the next few days? And in the old days, you could wait for some of those things because you had the time, but you don't have the time anymore. And you really need to be seeking that treatment from the beginning. Forget about a lawsuit. Forget about the legal stuff for your own health. Because if you wait too long in Florida, if you wait longer than 14 days, for an example, your insurance benefits under your auto personal injury protection policy, which is the only insurance that is required in Florida, will deny coverage for those medical bills. So you waited too long, the insurance company just won't pay for them. It doesn't mean that you might not be able to recover in the future if that happened, Rob. But the reality is, if you do those things, it just makes it so much more difficult and adds a layer of complexity to an already complicated matter.
So what tort reform has almost done is forced people to really get to see a lawyer quickly, to protect themselves just in case, it sounds like.
Absolutely.
And I didn't know that 14-day rule with your insurance carrier. I mean, that is huge for folks to know that if they're injured, and I love the way you put it, regardless of a lawsuit, if you've been in an accident, and we, we're old enough to realize and been in situations where you do something and the next day, I don't care if you're throwing luggage off a conveyor belt, you don't necessarily maybe not feel it right then, but the next day you feel it, maybe some delayed onset muscle soreness. And you're right, you get rear-ended or something happens, you may not just feel bad right then and there, but as the days go on, right, you get this effect of the potential injury. And as you said, person waits because either they're busy or they said, well, let me see how I feel. Wow, I did not know that, and that's some great information. Okay, well, in terms of the treatment protocols, I mean, I'm sure they're all different based upon the injuries, but any recommendations in terms of what a person should initially do if they are an injured party in an accident? Should they go to the hospital, even if it's not one of those, as you said, bleeding everywhere type of case? Should they call their primary? Should they go see a chiropractor? What do you think? I mean, as a family man, as a lawyer, what would you say is just to protect yourself? What should they do?
Right. Here's what it really comes down to, Rob, is a lot of this has to do with a little bit of common sense. I tell people, you don't have to get in the ambulance and go to the hospital and wait in the emergency room for, hours and hours if you don't have an emergency. Meaning, if you're not have a broken bone, if you're not feeling shortness of breath, if you didn't lose consciousness, if you're not bleeding and your faculties are generally okay, you don't need to get in the ambulance and go to the emergency room. The law doesn't say that. But what you need to do is you need to seek treatment. You should probably go to an urgent care. You should potentially maybe go to the emergency room, drive yourself. And if you don't do that right away and you do wake up the next morning and you're not feeling right, the terrible thing is your primary care physician most likely will not see or treat you for an auto-related injury because they do not accept automobile insurance coverage. And I'm not saying it's every primary care physician, but the significant majority of primary care and practitioners that are outside of the motor vehicle or injury realm do not see patients like that. So the unfortunate reality is you need to see an orthopedist, a neurologist, a physical therapist, whether it's chiropractic or what we would consider more traditional PT. You're almost better off contacting your lawyer and giving us the opportunity to give you the names of physicians that will see you and people that are in the game, for lack of a better term, that can bill insurance, understand the games that the insurance companies are playing, whether something is an emergent medical condition that's related to a motor vehicle accident or a trip and fall, or whatever the case may be, or if it's a pre-existing condition that is motor vehicle or emergency related, and how those billings happen. Because ultimately, the system is designed now that the individual, the common person, cannot navigate this by themselves. You simply cannot, unless you have the expertise.
That's something I was just thinking about. If someone is injured and they call you, you're like the captain of the ship here and steering this person in the right direction to make sure they get not only the appropriate care, but to make sure they get the care that they need as quick as possible. And you have medical professionals that you work with that you are comfortable referring those people to. And aside from what it costs to get that treatment, I know you indicated that there's insurance benefits that may be available both for the injured party and the party that caused the harm. But there's also things called letters of protection, right? That you can help a client get medical care without paying for. What is that?
Yeah, a letter of protection is basically a confirmation from an attorney's office that says, we will cover those medical bills or whatever's outstanding from the proceeds of any recovery that we get in court. And I'll tell you, post tort reform, we don't do that anymore because those now become evidence in the case. So because our law firm has good relationships with lawyers and good relationships with doctors and other associated medical providers, we don't have to do that. I invite people, if something happens, give me a call. I'll get you put in touch with the right medical providers. They'll do an evaluation. And sometimes the issue is, hey, Pete, The guy's fine. He's going to take a couple of Flexeril or a couple of muscle relaxer for the next couple of days. Should be okay. No problem. But a lot of times it's not that. And we have that relationship with those medical providers so we can get that care for you. And we can make sure that you're seen by competent and capable people, not just anybody or some fly-by-night person, and make sure that there's a system and a plan in place to not only get you treated, because that's really what it's all about, is make sure you're okay. And then we can deal with, the personal injury case and the claims after the fact.
Pete, and having been here for 35 years and been involved myself in the bar associations and other legal events here, and of course have a lot of friends that, or I should say colleagues, some friends practicing in the personal injury arena, and you can't drive here to Tampa and back without seeing all the advertisements and whatnot. And I know your firm, and I know other firms, and what strikes importance to me is that your firm and the folks at your firm, lawyers at your firm, you really have a granular hold and involvement in your cases. And I'm not criticizing other firms, but I know they use non-lawyers and different ex-claims adjusters or what have you to negotiate, to handle the cases more or less. Is that, am I not seeing that right?
No, you're absolutely right. And it's a very astute observation, really, because you are a good practitioner. You're a quality lawyer. And when somebody comes to you, and the cases, for example, the referrals we give to you, you actually treat people with respect, and you look at what's going on, and you actually want to help people. A lot of my industry, unfortunately, is based on people that work in sheer numbers. They're accountants, they're business people, they're not trial lawyers. And what they'll do is, it's a numbers game. I need to get as many motor vehicle accidents or slip and falls or injury claims in my door so I can shuffle them through the system and I can put them in the hands of people that are not lawyers, that are non-lawyer representatives under the guise of I'm supervising them. And they just push those cases through. They're not getting full value for their clients. Clients aren't really being treated like an individual. They're just kind of put into the system as if they're cattle. Cases aren't being dealt with individually and properly, meaning, are you actually getting a lawyer? Is a lawyer looking at the file at any time before a lawsuit is being filed, if this law firm even files lawsuits? Are the investigative tools being put into place to make sure that you don't have a defense of intoxication or a defense of, well, you didn't treat properly, or it might have been your fault and it's not our fault? Have all of those safeguards been taken into play? And a lot of the big firms, a lot of the advertising firms, I should say, just don't do that because they don't have time. It's a numbers game. It's not a quality game.
Well, you brought up a good point, and we spoke earlier off camera. How important is it for an injured person to have a lawyer that will actually go to court, one that will actually go to trial? Listen, as a lawyer, we have to be good negotiators, and that's important. But at the end of the day, if you aren't getting what you need from the other side, does the insurance company know some lawyers don't go to trial? Do they know that?
The reality is insurance companies track everything. You would be shocked at the level of the matrix that insurance companies keep in order to evaluate the value of claims. One of those metrics is, does the injured party have a lawyer? Simply having a lawyer increases the value of the claim to the insurance company, especially. And then they look at the lawyers themselves. Are these law firms that don't try cases? Are these lawyers that just, they'll take it up to, the demand stage in pre-suit, for example, to use some technicalities, and then pass it off to a different law firm in the future? The insurance companies know that. And the reason it's important to them is they know that they're not going to have to negotiate top dollar with that lawyer early on because these people do not file lawsuits. And it even goes beyond whether you file lawsuits, because when the plaintiff's bar, which is what we do, figured out years ago that the insurance company computer systems track this matrix, a lot of people just started filing lawsuits. But they don't really litigate cases. All they do is file the piece of paper in court. So the computer matrix then changed, and now it becomes more adept to saying, okay, this lawyer filed a lawsuit, but do they really litigate cases? Will they go to trial? Will they get a verdict? Will they appeal the case if it's necessary? Does this law firm, and specifically the lawyer handling the case, have the ability to actually run this ball all the way? Are they going to be a thorn in our side? And could it potentially be more expensive for us to fight this case than to settle it?
And dovetailing off of what you just said, it seems to me that given your influence, your firm's influence, and your impact and footprint here in the Tampa Bay area, when you are filing lawsuits and you're in court and you're arguing motions and you're advocating in a litigation setting, the judges know who you are, right?
Absolutely. And that's a matter of reputation and respect. The judges know who most of the lawyers are. The question is, do they see them on a regular basis? And when they see them, do they have something legitimate to say, or are they just spewing, throwing spaghetti up against the wall to see what sticks? The judges also know what's going on. So, and again, a lot of lawyers show up and they ask for things, not even knowing what the judge is most likely, going to do, or not really understanding how that particular judge evaluates something so that they can present something in a way that is going to pull at that judge and say, you know what, this may be the right thing to do. Judges, for the most part, at least the good ones, they're not taking sides. They're really trying to be as objective as they can be, but the lawyers have to give them the tools to be able to do the job. But at the end of the day, you walk into court and the judge knows that you don't play sloppy pool. They view you far differently than the people that either they never see or just they know that it's whatever happens today is whatever they're going to throw up on the wall.
And listen, at the end of the day, that's so important, right? I mean, I've always expressed to my younger associates here in the commercial litigation context or the criminal investigation, government investigation context, I mean, know who you're going to be presenting your case to or your story to or your facts to, because that's the person that you or the people you have to influence. Aside from a jury, know your judge. And you indicated you have these firms that don't go to court, don't go to trial, and they simply use non-lawyers, case managers, what have you, to handle cases. And the rare circumstance where they might, I guess, go to trial, they don't have that relationship or the experience or the insight that you would have because of your constant cases. I mean, you take these cases to court
all the time.
And I know you sit on panels, and we all go to the Clearwater or other bar functions with judges, and we know we like to ask what are your preferences and what is the local rules that you followed, and certainly when a lawyer comes in and does everything to the judge's satisfaction, I mean, it's never a bad thing,
No,
we've been in cases where we've seen maybe someone that is from out of town or someone that's not as experienced or shouldn't even probably be in the courtroom, and you just kind of scratch your head sometimes thinking they really need to do their homework better on presenting their case to the court, right?
Right. And the other thing is, for example, when you say out of town, I mean, we practice not only throughout the state of Florida, but we practice nationally. But because we speak throughout the state of Florida, I mean, I sit on rules committees. I've chaired evidence committees. I've chaired, practice committees with the Florida Bar. So when I show up, even though I'm not from Clearwater, they know who I am because I've sat in these committees with these judges and we've promulgated these rules together. It was funny, Rob. There was a time I was in court, and I remember this lawyer arguing this motion regarding whether or not a specific expert was allowed to testify under a standard called Daubert. Okay. And the judge is looking at me, and I'm just smiling. And at some point, the judge looks at the lawyer and says, "Hey, counsel, yeah, you got that case in front of you?" "Yes, Judge." "Will you take a look at that case and tell me who the lawyers were that litigated that case?" And the lawyer just looked at it like, "Oh, I guess that would be in front of you, Judge, and Mr. Sartes was the plaintiff's lawyer." Like, so those are the things that get you those little brownie points, when you have someone that actually knows what they're talking about. I wrote the rule. Judge, I know what the rule says.
I might that right there would have been maybe grounds for me to just then retire. I'm going out on a high moment. I'm done. I can't get any better than this. That's fantastic.
But that's what it is, Rob. When you're involved in your legal community and you actually are part of the process of promulgating the rules and the laws that we live by.
Yeah, no, 100%. And when the court looks to out into the gallery and recognizes a familiar face, one that is reputable, ethical, prepared, organized, all those factors that may not seem important are huge and vitally important for the court, especially with the limited time frame sometimes we have for hearings before the court. And when the court's looking at your binder for the hearing and knowing that you have everything tabbed and organized, and they relying upon you as the kind of the guiding the way, that goes a long way for the benefit of the client. And I know that's exactly what you do. And so clients really need to be aware of those nuances when hiring a lawyer. I mean, it can't be stressed enough because it does impact their case and the outcome.
Absolutely.
I would think, listen, insurance companies, they don't probably like protracted litigation. I mean, it's costly, right? And they want to get things done quick, right?
Well, not necessarily always, Rob. And the reality is insurance companies have the advantage because they hold the purse strings. Understand what you're trying to do is sell someone something that they don't really want. They don't want to pay for your injuries, but it comes in multiple evaluation streams from the insurance company's perspective. When they look at it, they're going to look at it and say, this is a business decision. Who's the lawyer? How well is the presentation of the injuries, the pain, suffering, inconvenience, the medical bills, the relatability of these injuries to this particular crash? And they evaluate this early on and they make decisions that say, should we just pay this person now so you don't have to go through the protracted litigation? Because chances are we're going to go to court and we're going to have to pay more tomorrow and spend more money fighting this guy than we will just paying the claim. And a lot of that is part of the decision making. I don't want my clients to go to trial. I don't want to put them through that process if I don't have to. But the reality is sometimes it's important that you do that. And you've got to know how to prepare that case from day one in order to put it in a posture where you can settle it maybe day 10, or maybe it settles day 30, or maybe it settles 6 months from now, or maybe you have to take it to trial and actually go all the way. But you have to prepare it from the beginning to give that client the best shot at maximizing their recovery as quickly as possible with the least amount of stress to them.
100%. I couldn't agree more. I always go back to the saying, failure to prepare is preparing to fail.
Absolutely.
And if you take the case in this, regardless of what your practice area is, but particularly these cases that are commercial litigation, personal injury litigation, criminal litigation or investigation, if you don't prepare for trial, it's likely that you're going to go to trial because you're not prepared to go to trial. And
right.
Those of us that do prepare as if we're going to go to trial, I think reach far better, lucrative settlements in the cases that you handle, because the other side knows it, the courts know it, and you're on much more stable grounds moving forward. Well, we're getting ready to wrap this segment up, and there's a lot of information here, but I want to ask, do you have any words of wisdom? You've been practicing a long time. You're influential in the community. You law students, high school students, young lawyers, other lawyers. Any words of wisdom that you would like to impart on people that just would something that I see your life and I watch you and your family, and it's always a joy to see all your kids and your wife and you out there doing what you do. And share some of that good stuff, man.
Sure. Let me share you two sides of it. The first side is the legal side. The world has changed. Insurances are becoming more expensive. Life is becoming more expensive. And a lot of people, especially those people that are more prone to causing accidents because they're stressed out, they're not paying attention, their life is in turmoil or in shambles. So those are the people most likely to be inattentive and to cause you an injury. Those people are cutting corners. And what they're doing is they're cutting their insurance coverages. They're cutting, their costs everywhere they can. 25% of the people out there on the street right now either have no insurance at all, or they do not have insurance that would cover an injured party. They just don't have it. So you need to really concentrate. And the first thing you should do when this podcast is over, you should go to your insurance policy and make sure that you have active and quality uninsured motorist coverage that protects you. You'd be surprised how many people call me, and I feel so bad to tell them that the guy that caused the accident and put you in the hospital for 2 weeks has no insurance, and you don't have any uninsured motorist coverage. So the $600,000 in medical bills you have, they're on you. They're now your problem. There's nothing I can do to take it off your back. So that's the first thing you should do. The second thing you should do is understand that the world is become a digital world. Be kind to people. Don't be angry. Everything that used to be something that you could get away with by, saying maybe a crossword to somebody, now all that's on Instagram, all that stuff's on social media. All that stuff is Exhibit A in court. Be good to people. Be kind to people. Don't belittle people, especially in the public. It will not do you any good. From a perspective of lawyering, listen, it is a lawyer's game. You cannot navigate this system anymore by yourself. There was a time that you could, but you can't anymore. And you need to pick a lawyer that's actually capable of doing the job for you. Pick someone that you respect, pick someone that you like to work with, and make sure that person is advocating for you. That's pretty much what I have. At the end of the day, Rob, we're all going to go around this, around that sun so many times. And the question is, what are you going to leave as a legacy? And you really want to, do right by people, do right by your family, do right for yourself, and try to, to make life as pleasurable as possible while we're on this planet.
Those are prophetic words. And, I'm reminded because my kids went to Calvary Christian High School and your kids went to Calvary Christian High School. But when you say do right by people, I'm reminded of, I think it's Galatians 4, what you shall reap, you shall sow, right? And that's really what it comes down to, what you're talking about. And I like that. I lost my train of thought, but what you indicated was that what I want to do is give the viewers an opportunity to get your phone number here in case you see sometimes people posting about movies on Facebook and they never list the name of the movie or how to find it. So aside from probably just Googling your name, how do people get in touch with you or your law firm in case they have a case?
Sure. The answer is, if you think you have an issue, just call me. I'm happy to talk to anybody. I'm happy to walk you through what's going on in your life. I'm easy to find. You can find me at the office, 727-441-9030 or 727-4-INJURY. Or you can also just email me direct. It's peter@greeklaw.com. I will answer your emails. Obviously, tell me that you saw me on Rob's podcast and you have a question. I'm happy to answer those for you. I do have a social media presence. You can follow me on that. And again, look for my name, Pete Sartes. That's my handle for most of what I do. And I am your personal injury lawyer.
And the firm is Tragos, Sartes, and Tragos in Clearwater, Florida, the home base.
Home base here in Clearwater.
It's been an amazing show. Tons and tons of useful information. I love when I learn stuff from a podcast show. This has been another episode of Time Is Not On Your Side. Stay tuned for additional episodes. You can find us on YouTube, Instagram, Facebook, LinkedIn, and other social media platforms. Remember, victory comes to those who are relentless in the pursuit of greatness. Thanks, and we'll see you next time.
You've been tuning into Time Is Not On Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.